Today we will start with Article 15 of the कानून-ए-शहादत ऑर्डर, जो डील करता है कि अगर कोई गवाह से कोई सवाल पूछा जाए तो वो कहे जी इसका जवाब मैं नहीं दूंगा क्योंकि इसमें तो मुझे ख़तरा है कि कहीं मेरे पे कोई जुर्म ना साबित हो जाए, तो वो इस एक्सक्यूज़ को नहीं ले सकता, उसको हर हाल में उसका जवाब देना पड़ेगा। अब मैं उसको उस आर्टिकल को मैं पढ़ने लगा हूँ कि उसका टेक्स्ट क्या है, उसके बाद फिर उसकी एलेबोरेट करेंगे। विटनेस नॉट एक्सक्यूज फ्रॉम आंसरिंग ऑन ग्राउंड दैट आंसर विल क्रिमिनेट। तो सिर्फ इस बुनियाद पे द विटनेस कैन नॉट रिफ्यूज टू गिव ए आंसर टू अ क्वेश्चन सिंपली ऑन द ग्राउंड दैट इफ ही विल गिव द आंसर ही विल बी incriminated to some other prosecution directly. You will say that actually if I will answer to this question, I will impliedly be criminated. I will be held responsible for to his estimation, not under the law. His assumption is that he may be liable for some prosecution if he will answer to that question. तो वो excuse नहीं है, it is not excuse, वो उसे देना पड़ेगा जवाब। Whether witness shall not be excused from answering any question as to any matter. So the thing is, first of all, it's very crystal clear that witness shall not be excused. The witness shall not claim the protection that I am not bound to answer this question. Only on any matter relevant to that matter must be what must be a matter in issue. That must be a fact in issue. That must be the controversy between the parties. That is not a random question should be put to him. The question also must be pertain to the relevant facts. In any suit or in any civil or criminal proceedings upon the ground that answer such question will criminate or may tend directly or indirectly to criminate such witness, or that it will expose or tend directly or indirectly to expose such witness to a penalty for forfeiture of any kind. So he cannot refuse that if he will, up to his estimation, that if he will respond to this question, it will be incriminated. The question, the answer shall criminate him. Incriminate means that that question, answer shall involve him in an offense, or that will expose him directly or indirectly any criminal proceedings to his. So he will say that I am not, but the law says he is bound to answer to him. Now there is also a proviso in this case, in this article, that provided that no such answer which a witness shall be compelled to give shall subject him to any arrest or prosecution be proved against him in any criminal proceeding, except a prosecutor giving false evidence by such. Now this is a protection further. The apprehension which was lurking into the mind of a witness, the apprehension that he was having that I may be exposed to the criminal some liability, this is a protection that don't worry, you shall not be liable for any criminal proceedings. No criminal action will be taken against you if you will compel you to give the answer merely on the question that there shall be no prosecution and there shall be no immediate arrest. And only if he will be being prosecuted for giving the false evidence, then this answer may be taken against him only for the prosecution of giving the false evidence. The protection offered by proviso to Article 15, ये जो उसको protection मिली है कि उसकी prosecution भी नहीं होगी, उसमें खिलाफ को immediate arrest भी नहीं होगी, कुछ नहीं होगा. Not cover every answer given by witness during the course of his trial. कि वो हर जवाब का उसमें protection ही उसको होगी. देखे ना, protection offered by proviso to Article 15 does not cover any and every answer given by a witness during the course of his trial. A witness has no privilege beyond the immunity conferred by Article 15. ये जिस आर्टिकल ने जो उसको प्रोटेक्शन दी है ना, उसी में ये इसकी मदद करेगा। उस प्रोसीडिंग में जिसकी उसकी हो रही है प्रोसीडिंग, उसमें कोई सवाल करते हैं और उसमें उसे डर है कि मुझे कहीं मैं कोई मुजरम ना बन जाऊं, मैं क्रिमिनेट ना हो जाऊं, तो उस केस में अब देखना वो केस क्या है, वो जैसा भी केस होगा, लेकिन दैट केस मस्ट पर्टेन टू द आर्टिकल 15। I'm going to explain the Article 16, that is about the accomplice. So first of all, we will define what is accomplice. Who is accomplice? Accomplice is a person who is a privy to an offence, who has participated practically into an offence, and he is one of the perpetrator of the crime. वो आदमी जिसने खुद शरीके जुर्म था, हर तरीके से जुर्म किया, शामिल हुआ, लेकिन किसी वजह से प्रोसिक्यूशन के पास एविडेंस ना हो, तो वो आदमी कहता है कि मैं भाई अप्रूवर बन जाता हूँ, अकम्प्लिस बन जाता हूँ, मुझे इसमें गवाह बना ले, तो वो कॉम्पिटेंट विटनेस होगा, वो गवाही दे सकता है क्योंकि वो शरीके जुर्म था। लेकिन उसकी कंडीशन ये होती है कि उसको फिर हमने पार्डन देनी होती है कि माफ़ी देगी, जिसको वादा माँ गवा देते हैं, ये अकम्प्लिस है। तो इसमें वो शरीके जुर्म होता है, उसने जुर्म किया हुआ होता है, तो वो कहता है जी मैं बतौर गवाह था, तो कहते हैं वो कॉम्पिटेंट विटनेस है, लेकिन वो हदूद केस में वो नहीं कॉम्प्रेस होगा। और नंबर 2, उसकी जो शहादत है वो विदाउट कराबोरेशन भी मानी जा सकती है। अब मैं थोड़ा सा यहाँ ही ये लफ्ज़ कराबोरेशन की बात करें कि व्हाट इज़ कराबोरेशन, वाई इज़ द डिमांड ऑफ द लॉ दैट देयर मस्ट बी सम कराबोरेशन, and for whom is corroboration? Corroboration is a demand of law only for the chair, only for the judge who have to decide a matter. If a judge, from the facts and circumstance of the case, either admits it, what is proof, or if he considers its existence is very doubtful, when the doubt is lurking into the mind, then he may ask for further corroboration. Corroboration mean कि इसकी जो शहादत हुई है, इसकी कुछ और मुझे तस्दीक चाहिए, इसकी मुझे और तईद चाहिए, उस तईद और तस्दीक को corroboration कहते हैं। तो वो फिर उसलिए कि जज की सेटिस्फैक्शन नहीं हो रही, तो जज चाहता है कि मैं इसको बिलीव तो कर लूँ, लेकिन अभी तक मैं ख्वाहिश है कि कोई और किस्म की सॉलिड कोजेंट टेंजिबल एविडेंस हो, ताकि मेरा जो जहन में जो डाउट है हैव और नॉट कि ये जुर्म हुआ है या नहीं हुआ, टू स्टेक द बैलेंस, टू अवॉइड द इनजस्टिस, कि ऐसा ना हो कि मैं किसी बंदे को छोड़ ही दूँ। तो उसके अगर कोई तस्दीक की तईदी शहादत आ जाए, तो अगर इसमें कॉम्प्रेशन ना भी हो, वैसे भी जो है ना कॉर्पोरेशन, इट इज़ नॉट ए रूल ऑफ साइंस, it's not even the rule of art, it is a rule of prudence. Prudence means that prudence means jurisprudence from some as a use the mental faculties to avoid the minimum maximum doubt into the mind. That's why as a prudence, इसमें दनाई के तहत, प्रूडेंस मीन मैं दनाई लफ्ज़ इसका इस्तेमाल करूँगा कि दनाई के तहत, सोच विचार के तहत, शऊर के तहत वो कहता है कि नहीं, इसको एज ए रूल नहीं, एज ए प्रूडेंस, कि मैं चाहता हूँ कि और शहादत आ जाए ताकि मेरे ज़हन में कोई डाउट ना रहे। The second thing now is that some people will say that there is a contradiction in Article 16 and Article 129 of QANOON-E-SHAHADAT order, that the testimony of the approver and the complex shall be corroborated, must be corroborated on the material particulars. Here the Article 16 says that it can be accepted without any corroboration and the conviction shall not be illegal. He is as good a witness as anybody else. So there is no contradiction. Only the point which has to be understood is that the corroboration is not a rule of law. It is only a rule of prudence, and it is only for the satisfaction of the court. And if the court is satisfied that actually this fact has been proved and its existence is probable and it is the belief of the court, then there is no need of any corroboration. So it is not a rule of law, it is a rule of prudence. So it is not a contradiction, it varies from the case to case and the surrounding circumstance of the case. What are those surrounding circumstances which, coupled with the other facts, whether it make the case very strong or if with the couple of the other circumstances which are present, surrounding circumstances, तो उसके तहत it becomes doubtful. So in these circumstances, the court shall seek for the corroboration. True?